Excellent. As you have heard, I work for the European Commission, more specifically for the legal service. So we're the in-house lawyers who plead for the Commission before the courts and who help with the legislative process. And in the latter connection, I had the privilege, I think I can say, to work on the DSA, among other acts. And I will try to give you some perspectives on the DSA, also knowing that it has already been very helpfully introduced, as you have just heard. Please bear in mind, these are my own perspectives. I'm speaking here not as a representative of the Commission. I'm speaking on a personal note. And more generally, I try to give perspectives of, let's say, including some criticism that you sometimes hear. So even the perspectives that I present are not necessarily my own. We will go through it not like article by article, also because it's too long and you have already had a brief introduction. I instead decided to focus on a few themes, which I projected on the screen, so hopefully you can see them. First, I say a few words on the regulatory approach. Then we go to what I call fundamentals. If there's time left, which may not be the case, something about the multi-level perspective. And then at the end, we have a conclusion. And the conclusion, also in case we don't get there now because of time reasons, there's also a few links to further reading. I don't have free books to offer, unfortunately, but I do have a link to a free article, which you could read on the DSA, giving a fairly basic introduction and overview, which some of you might find helpful. There's also a reference to a commentary on the DSA, which I'm in the process of writing now together with some colleagues. Okay, let's dive right in. Actually, before I do that, maybe one more thing about the name of the DSA. It has already been said that the term Act, Digital Services Act, or Gesetz in German, is fairly poorly chosen. I would go further. I think I can nominate the DSA for the worst named legal act in Commission history or EU history, because not only the word act you will not find in the treaty, but also the term digital services you will not actually find in the Digital Services Act. It uses another term, intermediary services, as you have already heard. But that's as a little aside. So on the regulatory approach, I speak about the following three topics. And the general idea here is to show a bit, let's say, the tensions involved and that with which the Commission first, when making the proposal, and later the legislator had to deal with when engaging in this kind of regulation. I shall explain that a bit further now. So one of the tensions or the balance that the legislator had to strike is between what you could call conservation and innovation. That's that is to say, as you have heard, there was and remains to some extent the e-commerce directive, a very old act dating from 2000. So it was high time that something new was adopted. But the choice was made not to start entirely from scratch and instead to reuse, as you've also heard, some concepts from the e-commerce directive. So there's an element of what I call copy-paste in the DSA, Articles 4, 5, 6, and 8, the liability exemptions and the prohibition of general monitoring. Some of you may be familiar with that. Secondly, there's what I call delayed maintenance, which refers to articles such as 16, 17, 20. And those articles deal with various topics. The first one, notice and action, which means that if in respect of a hosting service provider, a user sees content and thinks it's illegal, there should be a mechanism to inform the service provider so that the service provider can then subsequently act upon it and remove the content. So it's a complement to the liability exemption for hosting service providers. You already heard something about that as well. There's an obligation for the service providers to provide reasons when they take action, when they remove content, for instance. And as you have also heard already, there's a redress mechanism. And I call this delay maintenance because in my humble opinion, this should have been there from the very beginning. I think they are measures that are logical complements to the liability exemptions. And they are or were already provided for in some national laws, but for the first time now, they are also actually at EU level, but they're not innovative or spectacular, even though they are, of course, very important. And thirdly, there's an element of codification to the DSA in the sense that Article 7, the so-called Good Samaritan clause, which basically says if you proactively as a service provider make an effort to tackle illegal content, that will not be held against you in the sense that then you would be considered to be too active. As you've heard, there's this discussion about an active and passive role of an intermediary. But if you take these kind of measures in good faith, then you will not be considered too active and therefore lose the benefit of the liability exemption. And that is a codification because the court has, I think, to be honest, it wasn't all that unclear, or rather it was fairly obvious from the beginning, but in any case, the court has already confirmed that that is the case. So the article you could call codification. And something similar, even though a bit different, goes for Article 22 about trusted flaggers. Which are, as you may know, a particular type of notifying parties. And so an NGO tells the service provider who's focused on combating hate speech or anti-Semitism or child sexual abuse. So a specialized organization which has been certified as such under the DSA would inform the service provider. And then the service provider has to act as a matter of priority. That is a codification in the sense that it already exists in practice. So it's not yet in EU law in a binding way, but it's not entirely new either. Am I then saying that there is nothing new to see? There's nothing new about the DSA? Not at all. There's a lot of new and very interesting provisions, and it would go certainly too far to list them all, but I highlighted on the slide 3 articles, 3 mechanisms that the DSA creates and introduces, and in respect of which I'm very interested in seeing how this would work out in practice. And so there's the risk assessment and mitigation mechanism for the very large online platforms. So on a yearly basis, they have to see what are the risks that my services cause to, in the broader sense, society, and it's about systemic risks. If there's time, I will get back to that later. And subsequently, of course, they have to mitigate those risks. There's a very interesting article, I think Article 40, which creates an access to data. So basically it says as a researcher who meets certain conditions, you can be vetted, so basically certified by a national authority, and then you can, on the basis of a particular research project, be given access to data, again, of very large service providers, so as to study certain things, particularly how they deal with the type of systemic risks that I just mentioned. So that's going to be very interesting to see how that works out in practice. It's my understanding that these kind of mechanisms already exist on a voluntary, non-regulated basis. But of course, it's quite a different matter if you actually have a legal obligation for the service providers to give such access. And the third point I want to highlight is relates to the element of supervision and enforcement of the rules, which is of course very important. Somewhat complex, but the key point is that the Commission is charged with the task of supervising the very large online platforms. It's a bit more nuanced than that, but in particular in certain rules that only apply for those very large platforms, it's only the Commission that can investigate, impose sanctions, etc. Which is, those of you who have a background in competition law will not find that all that remarkable. But as was also already mentioned, this is a internal market act. And for these kind of acts, or basically any other field of EU law other than competition law, it is rather remarkable that the Commission is given these kind of tasks. And it will be very interesting to see how it deals with it, because of course, with power to enforce comes also a lot of responsibility, potential criticism. You need the capacity. So the Commission has been very busy to try to staff up and equip itself for this task, and we will have to see how that goes. Then I move on to another theme, so to say, that I want to bring to your attention. Also, as I said at the introduction, bearing in mind that there's also sometimes criticism of the DSA, which sometimes I think is also not entirely unmerited. And the criticism is, well, it's not sufficiently clear what the DSA says in a number of provisions. Again, I not randomly, but in any case, non-exhaustively mention a few provisions here. A very interesting one I find personally is Article 14, paragraph 4, which deals with the terms and conditions, the contractual rules imposed by the service providers in their relationship with their users. And the provision essentially says, well, when you apply and enforce those rules, for instance, to remove user content or to suspend a user who's been engaging in certain conduct, you have to be diligent, you have to be objective, and you have to be transparent. And not only that, you have to do that in a way that has due regard of fundamental rights and interests. Which I think is, again, one of those topics where you could write a PhD thesis about or speak an entire day. So this is not really the moment now, I think, to go into too much detail, but you can see that I think the potential, I think there's also, I would not really dare to go too much into detail because I'm not an expert, but it's my understanding that in Germany, as in the Netherlands, where I'm from, there's already case law of national courts. I'm not saying that the case law says the same thing, but the case law does say that in this contractual private relationship, you do have to take account of fundamental rights. But the question here, and that's the point I'm making, is, of course, well, that sounds good to take account of or have due regard, but what does that actually mean? That's something that will have to become clear over time. Two other provisions I mentioned, I'll be very brief. There's an Article 18, which says for these service providers, when you have certain information that gives rise to a suspicion of certain types of crimes, namely crimes involving a threat to life or safety of persons, then you are obliged to inform the authorities. Well, I think that the logic of the provision is fairly clear. But bear in mind, we're dealing with this in an EU level context. There is no criminal code under EU law. As some of you will know, there is some harmonization, but it's fairly limited. It's minimum harmonization, so member states go further. So what type of crimes are we talking about? Of course, the DSA does make an effort to clarify it a bit in the recitals and things like that, but still it's a question mark. And it's sensitive also because it involves, of course, these kind of notifications involve the processing of personal data. And another clause that I'll just briefly mention is the clause on so-called dark patterns, which essentially says, as a service provider, you cannot design or operate your website or other online interface in such a way that you manipulate the choices that the user may make, or you distort the free choices of the user, which again, I think, nobody would argue against, because manipulation is bad and distortion of free choices nobody likes. But what does this mean in practice is not such an easy question. Again, you could say a lot more about it, but it's I think it is a fair criticism. Yes, please.
There's a question of Mr. Zielinski. Does Article 18 also apply to people harming themselves?
If it's not a crime, no. So the question is, under the applicable criminal law, is harming yourself a crime? I'm not an expert, but I would think in most cases it is not. So the relevant element here is not so much the harm or the danger to the safety of life of persons. The question is, do you have a suspicion, a reasonable suspicion, taking account of all circumstances, that such a crime is being committed or has been committed or will be committed? And in that case, you have to notify. And then, of course, it's for the competent authorities. By the way, thank you very much also for bringing these questions to my attention, because I realized that while presenting, I cannot really keep an eye on the chat. So please feel free to break in again when there are questions. So a few more words on this discussion between about the alleged lack of clarity of some provisions, or in fact, let's say the open-ended wording, the normative approach rather than a very prescriptive approach. There's a reason, of course, why that is done. The most important reasons are, well, of course, we have to bear in mind we're covering a great variety of service providers in terms of their size, in terms of the type of services that they provide. So it's very difficult to be very prescriptive. A second element is that, as we all know, the online services sector tends to change quickly. There's innovation, which precisely the DSA tries to encourage. So also that means that you could write now very detailed rules, but the risk is that in 5 years they're outdated or not suited anymore, which argues for a more norm-based, open-ended approach. In terms of legal assessment, I think there's, if you look at the case law of the court, there's quite a lot of discretion for the service provider to say, for the legislator to say, we follow this approach. Rather, there's limits, of course, legal certainty in particular, but there's quite a lot of discretion. But the fact remains that there are from a policy perspective, there are downsides, of course, especially the uncertainty that you create for the service providers, but also for the users and also for the supervisory authorities. I think most of us will know or have experienced that vague rules that are not very precise, are sometimes very difficult to enforce if you deal with a non-cooperative service provider. As a last word on this topic, I should add, though, that of course there are some mechanisms to improve clarity in the DSA. For instance, quite a few provisions say the Commission shall issue guidelines, which are not binding, but at least give you an idea of what is at stake here. Another mechanism to improve clarity is the adoption of delegated acts, which the Commission is in the process of doing. And ultimately, of course, we have the courts, including the Court of Justice, which can provide clarity. Then another point, another concern, which is voiced in practice every now and then, at least by some authors or some parties involved, is saying, well, this is too much. It's over-regulation, what you're doing. And again, I think there's in truth, they have a point, let's say, to some extent. In fairness, the EU legislator was aware of this and tried to have a rather refined approach, in the sense that, as you've heard also during the last presentation, there's a layered approach. So not all rules apply to all services, but it depends on the type of service. In addition, as I also myself touched upon just a few minutes ago, there are special rules for the very large online platforms. So they are the biggest guys, the familiar names, you can all imagine who I'm talking about. And so once you pass a threshold of having 45 million users in the Union, then you will be designated by the Commission as a very large online platform, and then you will be subject to an extra layer of legislation. And those are typically the most intrusive rules, or the rules that impose the biggest burden on the service providers, like this annual risk assessment mechanism that I just mentioned. And in addition, there's also a certain exclusions for small enterprises. So below a certain threshold, you would be excluded. Still, I think we have to admit that the rules are broad and quite demanding. That is, in a way, also the very point. The DSA has 93 articles, which, as I mentioned, are fairly broadly worded. So in some cases, they impose fairly broad obligations. And it's also noticeable that during the legislative process, let's say the number of rules has increased considerably. The Commission proposal had 74 articles, so that went to 93. It's now up to 64,000 words, which is by EU standards at least. Let's say the DSA is a big baby. It almost doubled in size during the legislative process, which is, of course, principally a political choice. again, from a legal assessment, you can, let's say, it's unlikely that you can do much about this. It's a policy choice of the legislators, a political choice to say how far do we want to go. But important point to keep in mind, the natural inclination is, oh yes, and we should regulate this, and this should be provided for, and the service provider should be doing that. And of course, it becomes a longer and longer list. But the downside is obviously the burden that you impose on the service providers. Then you may say, well, I don't really care if, you know, the Metas of this world or the YouTubes have to do certain extra things. They have enough money anyway, which is true. But the more rules you impose, and if they also apply for startups and or mid-sized companies, potential challengers of the current big guys, then what you might be doing is entrenching the position of the big guys, which is precisely what we're not trying to do. We're not necessarily trying to reduce the position of the big guys, but what we do want to do, also bearing in mind that the DSA is part of a package together with the DMA, we do try to provide for a competitive environment where users have actual choices and where actual competition takes place. So there is certainly a policy downside when you look at imposing a great number of demanding rules. So then a few words on what I call the fundamentals. So until now, I spoke more about somewhat technical issues. And I've gone, again, conscious of the time. It will be a bit sketchy. I hope you forgive me that, let's say, there's more impressions, food for thought than actual really in-depth analysis. As it has already been mentioned, transparency and procedure in general is a very important theme if you look at the DSA. I give some examples, and many of the provisions are process-based. For instance, these terms and conditions that I touched on before, the DSA doesn't say you must have this in your terms and conditions or you cannot have that. It does set some basic rules, especially as to how they're being applied and enforced. And then if you have a problem, there should be address available, and you're exposed, you have to be transparent. You have to publish every year a report on what you do. But all this is procedure rather than substance, which has a number of reasons, but I think, conscious of time, I'll leave it to that. Of course, here and there are definitely substantive points, and I think by no means does this mean that the DSA is, let's say, not important or something, but the focus is on procedure, at least for the time being. And one of the reasons I do want to mention, which is that, of course, this is a first step. The DSA is the first measure of its kind worldwide. The focus is now on procedure. We have to be proportionate. We have to take also account of the fundamental rights of the service providers, their freedom to conduct the business, their freedom of contract, which I think played a role in the legislator's choice to focus on procedure. And let's say if in 5 or 10 years we find that this doesn't work or doesn't sufficiently address the problem, there is, of course, a possibility to amend the DSA or to take other measures. Moving on to the next topic is public policy framework, as I call it. The basic point I'm making here is essentially, as you have heard, until now under the e-commerce directive, which in turn is based on or inspired by, is a better word, US law especially, also German law to some extent, until now the approach has always been regulation by liability exemption. So there are liability exemptions. You've heard already something about that earlier. And other than that, there is actually not so much regulation. I mean, in the process, yes, for specific topics, copyright, as you probably know, terrorist content, but in terms of general framework rules, consumer law, of course, applies in some ways. But my point here is that under the previous approach, essentially, the service providers had an extremely broad leeway to set the rules. Right? If Twitter wants to throw Trump off its platform, it can basically do that. And it can basically do that in an unrestricted way. without rules such as the ones I just mentioned about, having to first have a clear rules, terms and conditions, to be clear upfront. What are your terms and conditions? To allow for redress, to be proportionate, as I just mentioned. So in the post-DSA world, Twitter could still, in a similar situation, throw Trump off the platform, but apply to the European situation. At the very least, it would ex ante need to have in place rules that say, that explain why why he's being thrown out. We don't allow this, we don't allow that, and that needs to be sufficiently clear. And then subsequently, there are the type of procedural safeguards that I mentioned. You should be provided with reasons. You should have redress. So that's the public policy-based framework.
There's one question. Ms. Hagendorf asks, is DSA applicable also for over-the-top platforms like Booking.com? Who is entitled to file a claim if the terms have unfair provisions for hotels? Typical German question.
Yes. Okay. Yeah. No, I anticipate. Normally, when you mention Trump, you get questions, but this is not so much Trump related. Well, I mean, of course, the question, let's say, the concept of over-the-top services is not one of the DSA, right? It stems more from the from the telecoms code. Mm-hmm. So the question here is it an intermediary service? Because as I mentioned at the beginning, that is the central concept, which falls into three categories: is mere conduit, caching, or hosting. Mm. So the question is it? I think the most important question is it the hosting service, which you can have to look at case by case. But essentially, we're talking about service providers that store and disseminate to the public content provided by users. And I hope you understand, I rather do not go into particular companies and, I don't think I could, but that's the way to look at it. So it's not, the concepts are a bit different from the concept under the telecoms code. And you just have to apply, let's say, the rules of the DSA itself.
Yeah, okay.
So I also would like to bring to your attention that, at least in my personal assessment, there's a bit of a shift of focus as compared to earlier regulation that at EU level was adopted in this field. As you may know, well, I think everybody knows about the copyright in the digital single market directive a few years ago, the terrorist content online regulation may be familiar to some. The Commission adopted, I think in 2018, a recommendation on tackling illegal online content. So the focus for a long time has been specifically on, we need to tackle illegal online content provided by the users, and the service providers need to help in that process. And to some extent, that is still the approach. There's definitely in the DSA rules that try to do that. I mentioned already this notice and action mechanism through which users can bring alleged illegal content to the attention of the service providers, who can then remove it. I already mentioned the obligation to notify suspicions of crime. There's the risk assessment system, which includes an element of assessing what are the risks that my service is used for the dissemination of illegal content. So the DSA definitely seeks to tackle illegal content, but it's also noticeable what is not there. Even though there are some rules on injunctions, as Thomas has mentioned, there's not a legal basis for national authorities to issue these kind of injunctions. So the legal basis needs to be found in national law. There are no stay-down type of rules. There's no obligation of mandatory monitoring. Rather, there is, as we have seen, a prohibition of general monitoring. But there's not even something on specific monitoring. Which probably also explains why the DSA was a lot less controversial than the copyright directive, for instance. And of course, there were debates on the DSA, but overall, its legislative process was fairly smooth and quick by European standards, at least. And the shift of focus that I'm pointing out is that increasingly, although not exclusively, the focus is on the own conduct of the service providers. And I list a few articles as examples. I already mentioned these dark patterns, and that is something that service providers themselves do. It has fairly little to do with the content that their users provide. There's rules on the recommender system. So of course, the systems that service providers use to bring certain attention to the, certain content to the attention of the users, which are also like their own practices. There's an obligation to protect minors. There's the risk assessment system, which I mention again, because of the 4 type of systemic risks that are mentioned there. One is tackle illegal online content, and the 3 others are let's say, more focused on the own conduct of the service providers. They should not, for instance, negatively affect the exercise of fundamental rights by what they do, not so much by what their users do. So I think that that's important to keep in mind as well. You could say it has increasingly, also during the legislative process, the DSA has developed more and more into a consumer protection type of act, which was always to some extent, and it's not fully because it doesn't only cover consumers, but it's still going a little bit in that direction. And I think, I mean, you also have to stop me, Thomas, when time is running out. I shall at least make this point and maybe one more, but please just give me a sign when you say it's enough. I do think it's interesting to note, if you look at which actors are actually involved here in the application of the DSA. So under the e-commerce directive, there were actually very few actors involved. You have, of course, the user who provides content. You have the service provider who stores it or transmits it. And then typically you have a third party who says, I'm harmed, this is illegal content and I'm being harmed by it. And then, for instance, notifies the service provider and asks it to remove. But that's pretty much it. So also in terms of public supervision, there wasn't all that much. Also because there were few substantive rules, if you look at this directive. I don't say no rules, but relatively few. And for the DSA, it's very different. Okay, on the public side, I already mentioned the Commission has an important task in supervision. You, Thomas, already mentioned the digital services coordinators at national level. There's also data protection authorities involved, potentially other authorities. So at the public level, there's an increase, but the most interesting increase is at the private level. I think, because there are these mechanisms, as we touched upon to some extent, for out-of-court dispute settlement, for trusted flaggers, for auditors who have to check whether a service provider complies with its obligations, at least for the very large ones. There's the vetted researchers that I mentioned. So these are all third parties, sometimes civil society type of organizations that are now also involved in the process. And that's, I think, a strong point of the DSA. If we, and that's a bit the underlying philosophy, if we think that the dangers that are associated with some of these services are so big that they affect our society, right? For instance, in relation to elections, just to give one example, or terrorist activities, or many others, the mental health of children, things like that. If the idea is it affects society, well, then it is, of course, quite logical to try to have an approach which also involves many elements of society and not only classical public authorities in the process of application. So I think it's a strong point, but at the same time, it is also a potential weak point in the sense that, well, these authorities, or sorry, these organizations, they need to be there. Right? If there is no body that says, hey, could you please certify me as an out-of-court dispute settlement body, or as a trusted flagger, or as a vetted researcher? So if there's no uptake from the grassroots, from bottom up, all these interesting mechanisms will not mean anything because there's nobody applying them. And there's, of course, a risk that there will not be uptake, but there's also a risk that in one member state, which may have a particular tradition or more, financial means or a cultural dimension or whatever, there is a lot of uptake, and in another member state there is not. So there could be disparities between the various member states, and that's, of course, something that would negatively affect the application, or could negatively affect the application of the rules. I, as a matter of speaking, look at you, Thomas. If I can make one last point, but again, please stop me if we're running out of time. I do think perhaps it's worthwhile to have a little look at, let's say, how does this relate? Because any EU legislation you typically look at, among other things, or from several angles, but one of the angles is typically, how's the balance between what you do at the EU law and what you do at national law? Well, the e-commerce directive also always allowed member states, as some of you may know, to impose a duty of care of service providers. So it has relatively few rules itself, but it says, well, member states, you can do quite a bit. The DSA approach is very different in this regard. You could say, well, now we do that. We impose this duty of care at EU level. And then recital 9 is relevant because it explains, in accordance with fairly standard case law of the Court of Justice, that, well, given that this is intended as full harmonization, at national level, you cannot take any measures on matters that fall within the scope of the DSA. Mind you, there are, of course, limits to that scope. And even within the scope, if you pursue a different objective, if you, for tax reasons, impose certain obligations on the service providers, that can still be done, but not for similar objectives as those pursued by the DSA. And of course, that's rather difficult to assess case by case, but that's the general rule. And of course, also at national level, given that the e-commerce directive continues to exist, you will always have to respect Article 3 of the e-commerce directive when, as a member state, you do think there is scope to impose national rules. And that is to say, you have to respect the country of origin principle, meaning that in principle, with exceptions, you can only impose obligations on the service providers established in your own country and not those established in another EU country. I think maybe that is the last point, or actually the very last point. Sorry, I'm making a third last point, but this still goes with the previous one. What I just said sounds like, oh, full harmonization at EU level, there's nothing to do at national level anymore. Obviously, that is not the case. For supervision and enforcement, there are still important tasks, despite the Commission having important tasks in relation to the big guys, there are still very important tasks at national level as well. That's why we have the digital service coordinators. There's also, as I mentioned, this uptake that you need to have from, let's say, civil society, vetted researchers. They need to be vetted, which is also a task of the national authorities. In addition, it's for national law to say what is actually illegal content. It's not the DSA that determines that, which also naturally means that there are differences between the member states. And also for the type of injunctions that I mentioned earlier, there are some rules in the DSA, but that need to, of course, to be respected. But fundamentally, the legal basis has to be found in national law, or in some cases in other types of EU law for terrorist content or copyright, but it's not in the DSA. So of course, let's say the balance between national and EU level is different, and there has been obviously a shift to national EU level, but that doesn't mean at all that at national level there would be nothing to do anymore. And I think I will leave it to this. If there's still questions, and of course subject to time restraints, I'd be happy to take them. I indicated my email address. Should you be, if you want to reach out with a question or something later. And I showed also here this reference to this free article that I mentioned, freely accessible, and to the commentary on which we're currently working. And thank you very much for your attention.